My name is Blake Marcus. I work with the Minick Law firm in Asheville, North Carolina, where I specialize in criminal defense, specifically in DWI defense. Our firm also practices in family law, as well as personal injury law as well. Today, we're going to focus on the criminal side of things. So my goal today is to hopefully give you, the audience, a better understanding of bail. So in North Carolina, if you were charged with a criminal offense, you're most likely going to end up in one of the many county jails here. So at the end of that time in jail, the magistrate, who is a judge who is actually in the jail, has a job of setting terms of release. This means that they will set the terms for which, if you comply by those terms, you'll actually be released from custody. So there's not as much complexity as people feel in this kind of situation. So the magistrate has the ability to set the bail, if there is going to be bail, and they're using a multitude of factors in assessing whether to allow you to be released and under what conditions to be released. So some factors they consider are the severity of the offense you've been charged with, whether you are a local person or whether you live far away, out of state, if you will. And they also consider whether you're going to be a flight risk, whether you actually show up to your court date, and as well as if you will be a danger to society or danger to others in society if you are released. So that is the basic landscape that the magistrate is working with, and many times the magistrate will have your criminal record they can look at, but the magistrate will make the decision relatively quickly. So once the magistrate makes that decision, it can fall under about 1 to 4 categories. The best case scenario is a situation where the magistrate releases you upon a written promise to appear. And this is a situation where the magistrate has deemed you a low flight risk and you've committed a low-level misdemeanor, not a very serious offense. So if you just you pretty much sign your name, write a written promise to appear, and you just have to go to court. Another situation is where you are released into the custody of another. This is a situation where you are charged with an implied consent offense, such as the DWI, and you are still potentially the person is too intoxicated or impaired to leave on their own accord. So they are released into the custody of another person, such as a parent, guardian, wife, husband, etc. The next situation is where you are actually given a cash bond. Okay, this is where you actually have to give a certain amount of money to the jail for you to be released from custody. And the cash bond can fall under 2 circumstances. It can either be a secured bond or an unsecured bond. If you are given an unsecured cash bond, this is a situation where, though there is a bond set, you do not actually have to pay any money to the jail to be released. So in essence, as long as you keep going to court, which is the main point of bond, then you'll be fine. However, if you miss court for any reason, then that bond will go from unsecured to secured, meaning you have to pay that amount to be released from custody. And if that bond amount becomes secure, you're not going to be released until it's paid off. So cash bonds can be relatively high, relatively low. It really depends on the charges, severity of the charges, your previous criminal record, flight risk, as well as danger posed to the community. So in essence, many people cannot afford a very high cash bond. Most people can't. So this is where bail bondsmen come into play. If you consult with a bail bondsman usually charge you a 10 to 15% fee of the total bond amount to be released from custody. So in essence, let's say your bond amount is $100,000. The bail bondsman will usually charge you 10 to 50% of that, which is about $10,000 to $15,000 to be released from custody. You pay that to the bondsman, and they will front the rest of your bail to allow you to be released from custody. You will not get any of the bond money back. So unlike a cash bond where you will actually receive the money back if you paid it on your own behalf, if you pay the bail bondsman, that 10 to 15% is the fee that you actually pay to the bail bondsman to front the cost to have you released from custody. So I just wanted to give you, and thank you for watching, I just wanted to give you a brief overview of how the bail system and bond system works in North Carolina. Getting charged with a criminal offense is a very scary and frightening experience, especially if it's your first time. But I hope this video sheds some light on kind of the complexities of the bond system. And thank you for watching this video. Again, I am Blake Marcus. I work with the Minick Law firm in Asheville, North Carolina. And thank you.